Karmelo Anthony has a great chance of getting a new trial. What's going on, everybody? Welcome back to On Go. I'm Uda, and today we are going to be breaking down a brand new court filing in Karmelo Anthony's case. Now, the defense has officially filed the motion for a new trial, along with the motion to recuse Judge John Roach. Now, in this live stream, we are going to read through the actual court documents together, 190 something pages. I'm going to try to get through all of it. All right, we're going to do this all together and explain the legal arguments being made by the defense and discuss what these filings could mean moving forward. I'll be giving my analysis as we go, but I will also be letting you read the documents and decide for yourself. So if you're joining us live, let me know where you're watching from. Hit the like button, share this video, subscribe to the channel as well. And if you enjoy the court document breakdown and legal news coverage, be sure to subscribe. All right, make sure y'all all subscribe. So let's get right into the documents. All right, I do want y'all to be able to see this. I think y'all can see this. Y'all just let me know if y'all can't see it, and I'll zoom it in. I'll make it bigger for you as well. I could even do that. Okay, I can even do that as well so that y'all can see the documents. All right, cool. So salute to everybody. Let's get into this read. We got a lot of pages to get through. All right. Hold up. Better yet, let me make my microphone better for y'all. Hold up. So y'all can really hear me better. Let me put on my mic. Salute to everybody. Y'all hit the like button as y'all coming in. Make sure that y'all are hitting the poll. I want y'all all to vote. I got a question in there as well. I want y'all to comment. I want y'all coming out the clouds. And I want to hear what y'all have to say about this case and everything that's going forward. All right. Everybody's opinion matters here. This is On Go. This is not the other channels. This is not an echo chamber. Everybody's obligated to have their own opinion. I'm not here to change anyone's mind about anything that I do. Have your own mind, but that's when we come together and start to build. Then we get to decide things for ourselves. All right. So everybody, as you come in, make sure you're hitting the like button. That's how you get it on Go. If you subscribed, all the new subscribers, if you're coming out the clouds, if you're new here and you're subscribing, make yourself known, you know what I mean? So I can salute you and shout you out as well, because salute to all the new people that's here, right? Cool. Let me just fix my microphone. All right, cool. Yeah, hear me good? Let me know. I think we better now, right? Cool. Almost forgot my mic. All right, let's get right into the documents. Okay. The state of Texas, first Karmelo Anthony. You already see where it's coming from. The defendant's motion for new trial and brief in support, right? To the honorable judge of said court comes now the defendant Karmelo Anthony by and through the underdesigned counsel and pursuant to the rules 21.1-21.9 of the Texas Rule of the Appellate Procedures, moves the court to set aside the judgment of conviction and sentence and grant a new trial. The defendant moves for a new trial on 4 grounds. First, the court committed structural error when it materially restricted public access in violation of the right to a public trial. That is a big one. Second, the state's repudiation of the parties' unrecorded evidentiary agreements after the defense relied on it coerced the waiver of Mr. Anthony's right to testify and denied him a complete defense in violation of his constitutional rights. And third, the trial court improperly instructed the judge on the applicable law. Fourth, the cumulative effects of these errors warrants a new trial in the interest of justice. Sound like they cooking with grease already, bruh. The first thing, the public court. What happened, bruh? Y'all locked it off. We couldn't watch it on the TV, nothing. This is a state case, not a federal case, you know. I think that's what led to all the misinformation. And it seemed like they wanted to siphon out the information, and they left it only to the big companies, to legacy media. And we already know the news be telling lies to your vision. So believe the news if you want to, bro. Go ahead and believe it. Introduction. This case presents a structural public trial violation. The court had authority to manage courtroom security, decorum, and capacity. But once it adopted and administered restrictions that foreseeably excluded members of the public from a high-profile criminal trial. It was required to make record-supported findings and to consider reasonable alternatives to closure. The court did neither. The access regime limited public attendance to a narrow daily admission period, a small number of seats, and no continuing overflow or audio or video access after jury selection. Because that closure affected the trial proceedings themselves, and for the three additional grounds set out in this motion, the defendant asked the court to set aside the judgment and grant a new trial. In support, the defendant shows the following: the defendant's motion for a new trial and brief in support, page 1 of 63. Hold up. Cool. Let me just make sure y'all see everything good, right? Y'all seeing everything good? Make sure everybody slapping the like button. Everybody voting on that poll. I should see 7 votes on that poll. I want everybody voting straight. If you don't want to like, you can go. It's not that serious to me. Obviously, you like misinformation, and you know what I mean? You just like running around like Jeff Metcalf. You know what I'm saying? Go ahead, bro. Go ahead. Go with your cousin Jeff. It's all right, man. We ain't begging you, bro. Do the right thing. Straight. Don't tell me about Dr. Umar Johnson. He taken for beat. Look, the case and the verdict. This case arises from an altercation at a high school track meet. The defendant, Karmelo Anthony, was charged by indictment with the unaliving of Austin Metcalf, alleged to have been committed on or about April 2nd, 2025 in Collin County, Texas. The defendant pleaded not guilty. His defense at trial was self-defense, that he used force he reasonably believed immediately necessary to protect himself. The court's charge submitted the offense of M, the lesser included offense of manslaughter, and the law of self-defense, included the justified use of deadly force. The defendant did not testify. On June 9, 2026, the jury found the defendant guilty of M, and the court imposed a sentence of 35 years confinement. These matters appear from the indictment, the court's written charge, and the judgment. The case drew national attention from the outset, and the court appointed a public information officer to assist with media credentialing, communications, and access logistics. In practice, public and media access were administered through that process. What follows is how that access was in fact administered: before trial, at the perimeter of the courthouse campus, and at the courtroom door, and after the verdict. B, secrecy before trial, the gag order, chamber conferences, and no public pretrial hearing. Now, the closing of the prosecution to public view began more than 10 months before trial. On July 28, 2025, acting sua sponte, and on no party's motion, the court entered an order prohibiting extrajudicial statements, a gag order binding the parties, their attorneys, witnesses, law enforcement personnel, courthouse and court staff, and court-appointed officials, which by its terms remained in force through trial. Covered persons with first-hand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimony absent written approval from the court. The gag order's terms were sweeping. Unless first approved in writing by the court, no covered persons could make any extrajudicial statement that A, addresses the character, credibility, expected testimony, guilt, or innocence of any party or witnesses, that discusses the defendant's motion for a new trial in brief. Oh, let me just do it like this. All right, cool. Okay, evidence anticipated to be introduced at trial or that intends or is likely to influence public opinion or potential jurors, restrictions expressly applicable to any public medium, including traditional news outlets and social media, and enforceable by contempt, fines, attorney discipline, or other remedies. Its findings were 3 sentences: that media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial, that alternative measures, venue change, jury screening, sequestration would be inadequate alone, and that narrowly applied speech restrictions are necessary to protect juror impartiality. Now, no evidence is recited. The order permitted only procedural announcements, hearing schedules, court filings, and statements required by legal or ethical duty. A safe harbor that presupposed filings that the public could see. By its terms, it would yield only to further it would need only to further written order of this court, and the amended order later reaffirmed it until the completion of the trial. In the 10 months it operated, no person was ever alleged to have violated it, so far as the public record reflects. Now, the substantive pretrial work of the case was then conducted out of public view. The parties' pretrial conference with the court included a May 21st, 2026 conference in the chambers, at which the parties' evidentiary understanding was described to the court, and a May 29, 2026 meeting addressing trial security and scheduling occurred in the chambers outside open court. No reporters' records of them exist. A matter the hearing will confirm. No pretrial hearing was ever held on access restrictions, and the register of actions reflect no such setting. The public docket discloses no motions in limine and none of the substantive pretrial litigations that in fact occurred. Filings that were hand delivered rather than filed in the district clerk's public record. A member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. C, the amended order, the written terms of access. On May 18th, 2026, RP to my pops, that's his birthday, the court signed the amended order regulating trial proceedings, media access, security, and courtroom decorum, entered to govern all aspects of the trial proceedings. The order recited the directives of Waller v. Georgia and Shepard v. Maxwell, found that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, and promised reasonable public access consistent with constitutional requirements. I don't know why I keep doing it, bro. Because I don't have it zoomed like this. If I do it like this, then, but I want y'all to see it better, man. Some of y'all gonna have to work with me. Hold up. This is the way y'all gonna be able to see it the best. I'm gonna try to do this. I keep forgetting. All right, cool. The defendant's motion for new trial in brief and short, right? Okay. Its operative terms were these. The courtroom would open at 8:30 a.m. for the media at 8:40 a.m. for the designated family members, and at 8:50 a.m. for the general public. No more than 9 members of the media would be admitted. Seating would be on a space available basis. The doors would close promptly at 9 a.m. Individuals arriving after that time would not be admitted until a recess, and no person who left could re-enter except at a recess. All persons attending were required to dress in appropriate business attires. Hats and caps were prohibited, and clothing or items displaying messages, logos, symbols, or images related to the case or otherwise distracting or potentially prejudicial were banned. The order appointed Steve Stoller. Let me go down like this. Cool. The order appointed Steve Stoller, identified in the order only by a personal email address and a cell phone number, as the court-appointed public information officer, committed media credentialing to that office, and announced that the court will not intervene in or resolve disputes among members of the media regarding access or seating. The order contained no provision for an overflow room, an audio feed, a video feed, or any other means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object any of it. The order also closed the courthouse grounds themselves. It placed the entire courthouse campus, including parking lots, sidewalks, green space, or any other designated area, under a nightly curfew from 11 p.m. to 6 a.m. beginning May 31st, 2026. It designated restricted zones on an attached exterior map, and it ordered the Collin County Sheriff Office and law enforcement personnel to ensure compliance with this order at all times during the trial. Under the order's enforcement clause, any violation, including citizens' presence in a courthouse parking lot or on green space besides the courtroom before 6 a.m., exposed the violator to immediate removal from the courtroom, courthouse, or courthouse grounds, and is in position of sanctions. Damn, sanctions and all that, including contempt of court. Yo, that's crazy. If you want to grass, you in contempt of court, bro. Nah, bruh. They did too much with this case, bruh. It still became the race bait and all the thing that it became anyway. So what was they stopping? That's too much. You was supposed to get a contempt of court. And no warning is required prior to enforcement. No findings of any kinds accompanied the curfew. B, access and operation, the curfew, the parking lot, and the pre-dawn line. Pre-dawn line. Gun line, boss. That's what it sounded like to me, bruh. You seen like, it's a gun line, boss. Sound like to me, bruh. You in them states. In operation, admission had almost nothing to do with the order stated at 8:50 a.m. public entry time. Because the public seats were few, members of the public began arriving in the pre-dawn hours, often between 4 and 5 a.m. That's when Neek was telling me she was arriving, before court was in session, and while the campus... Why are they doing this? And while the campus curfew was still in force, and sheriff's deputies enforcing the orders stopped arrivals at the parking lot and restricted entry onto the campus until the curfew lifted at 6 a.m. The queue that actually determined who would see this trial thus formed at the perimeter of the courthouse campus hours before any proceeding convened. A member of the public who appeared at the order's appointed hour of 8:50 a.m. had, a practical matter, no prospect of a seat. The line itself was administered without without published standards, and that even-handedly, individuals were permitted to move ahead of members of the public who had already waited there for hours. Thelma Anderson, who arrived early on June 6th and initially held approximately the 7th position, was displaced to approximately 35th beyond the number of available seats and was excluded from that morning's procedures. Tamitra Carter, identified as number 7 on an early arrival list, was removed from the line on June 5th and lost the morning session. Admissions was run through 2 lines, one for a media list and one for everyone else. And media outlets denied credentials were directed by the public information officers to seek entry through the public line. Whereas a Collin County Sheriff's deputy administering the line acknowledged on video persons who print out whatever and make themselves like they are media consume the public few seats, a practice that the officers conceded they could not police. Like, people was doing too much. It's crazy. There was a zoo out there. Inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. Bro, they provided an overflow room and then withdrew it. At the Diddy trial, we had multiple overflow rooms. Multiple. And it's a federal building. Actually, a place where you're not supposed to record and they're not going to stream it to TV. This is a state case. You're supposed to be able to record. I went to Harvey Weinstein's court case. Harvey, what you doing here, bro? Stop playing me, Harvey. Stop playing me. No courtroom outburst. Would have had to get on happy feet. Facts, bro. You could record in state court, bro. You could bring a whole camera in there like this, like a news guy in a state court, a big old camera. You could bring it. So I think this made this case more of a media circus, if you ask me. Hold on, let me just check on the chat, see what's going on. Cool. Yeah, this is crazy, bro. We got like 100 and some pages too. So gonna be here for a while. All right. Inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. The courtroom held approximately 70 seats. By the court-appointed public information officer's own written account, 15 were allotted to the prosecution's family, 15 to the defense's family, and 9 to the media, including a courtroom sketch artist with additional seats for courtroom staff. Now, leaving about 24 or so seats for the general public. The trial later confirmed the arithmetic on television and some 200 requests by media and 27 to 32 public seats were that we rotated every day. None of these allocations appear in any order, and the 15 seats family allotment was not honored in practice. The defendant's own family was limited to 8 seats in total, so that his grandfather and his aunts were excluded from the trial, while those admitted were required to register a day in advance and were warned that a visible facial expression could result in removal. Just even making a facial expression, you're getting kicked. This is crazy. This is crazy, bro. This is crazy how they ran this courtroom, yo. And I was supposed to be at this trial, so I'd have been like, "What the hell is this?" For jury selection, the court furnished what its order, okay, it said the court furnished what its order had never promised, an auxiliary viewing location outside the courtroom, a functioning overflow room where members of the public who could not be seated inside observed the proceedings on June 1st and on June 3rd, 2026. On June 4th, 2026, the first day of testimony, the court eliminated it. So no announcement was made in open court, no order was entered or modified, and no findings were made. Public access was thereafter confined to the seats inside. Nor was the elimination a reaction to anything that occurred at the trial. As early as of May 25th, 2026, the public information officer had advised an inquiring journalist in writing that there will be no overflow room during trial. This, although the county's own media request intake form listed overflow room access among the accommodations that could be requested. When Thelma Anderson asked the court for an alternative viewing location, there was no way even to file the request. The county's electronic filing system had no category for a courtroom access request in a criminal case. So the request was routed by email to the court coordinator and on to the public information officer, and it was denied outside any judicial proceeding. And on June 5th, the public information officer confirmed in writing that there is no overflow room. So you really had to get there from 4 o'clock in the morning, bro. This would have been crazy, bro. I'm surprised. Yo, shout out to Nico, my sister, Queen Sheba, everybody that was there, bro. That's crazy. You literally had to be there for like 4 o'clock in the morning in a crazy, scracial town. It's crazy, bro. Straight. You got to be packing like Schwarzenegger in that movie, bro. Not playing around. No. Anyway, day by day, the accommodations existed only while no witness testified. So the pattern is visible day by day. During jury questionnaires and voir dire, June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated inside. On June 4th, the first day of testimony, that room was eliminated. And on every documented day of the testimony thereafter, members of the public were excluded. The accommodation existed precisely when no witnesses were testifying and vanished precisely when the evidence began. So they give you a little list. Monday, June 1st, jury questionnaires, auxiliary viewing room available outside the courtroom. At least one member of the public turned away on a purported jury members only rule. Okay. Could have been Thelma, one of those people that we was naming, right? On Tuesday, June the 2nd, none of the courthouse closed. So it was none. On voir dire. On Wednesday, the 3rd, it was voir dire, auxiliary viewing room in operation, the overflow public observed the proceedings from it. So only for like the jury kind of selection. By the time it really got to the case, they clipped out the overflow rooms. If you don't know what overflow rooms are the other courtrooms that they open up to let the public in, not only public, because lawyers go in there too as well. Other members of the media may go because you might not find a seat in the courtroom, the actual courtroom, right? So they'll open up overflow rooms. Like in Diddy's trial, they kept open. If they needed more overflow rooms, they would just open them up. So it would have like we'd be on like the 24th floor. There was always an overflow room like on the 24th floor. Diddy's trial was on the 26th floor. See, they had security up there. It was like Fort Knox up there, Fort Dix for Diddy case, but Fort Knox. So they would open up other overflow rooms. When Kanye came, they opened up a whole different room for Kanye. You see what I'm saying? They opened up another one, I think, on like 21 floor. They opened up a whole thing so that he could look at the case. There's a TV in there. I think Neek described that there were multiple TVs. There was a TV, I think, off to the right, and then they had like a TV above, straight ahead, so that you could see in the overflow room. And then they got the speakers and stuff, so you get to hear it. But you're in the actual courtroom. You got the judge's bench. You got, the seats on the side, inside the court for the lawyers, the attorneys, prosecutors, and then you got the audience seats. So the overflow room that you're in is not a room. You're in a literal courtroom, just like the courtroom that Karmelo's in. But you're just in an empty courtroom. There's no judge there, and the TV monitor's on. And in that case, I would guess that the TV monitor was on in Karmelo's as well, because in the audiences, there's people sitting way in the back that are looking at the TV screen to follow along with the case. You know what I mean? Cool. All right. Thursday, June 4th, testimony begins. State's case. Viewing room eliminated as soon as the states got up the bat. Without announcement, order, or findings, from a line of roughly 80 to 100, approximately 27 admitted. Yon, Allen, and Anderson were excluded. They saying who was excluded. Neek, they excluded you in this paperwork. I'm gonna find my girl Neek. Yo, Neek, they got your ass up in the building. Yeah, but Nick went in the building like damn near every day. She was there. Testimony states case. I think she got there every day. Anderson excluded. Carter removed from the line and denied the morning session. PIO confirms in writing that there's no overflow room at this day. June 6th, the testimony of the state rests. The defense case begins. Yo, they ran up there for a couple of days and rested, bro. You know what I'm saying? The state's case begins. Hold up. The testimony of the state's rests and the defense case begins. Anderson displaced from approximately 7th to 35. So you on the line 7th, waiting at 4 in the morning, bro, and get displaced to 35th and get knocked out of the people that can get in the court. Anderson was sick. Anderson was sick, bro. He was sick. Excluded until mid-afternoon, though. West was removed from the courthouse for expressive clothing. Remember, you can't have no logos. You can't have nothing that's saying free Karmelo, nothing like that. You got to have business attire to be in that courtroom. And you can't make a face. If you make a certain facial expression, you could be removed from court. So this was a tight ship that they was running. Crazy. June 8th, on Monday, the defense case resumes and concludes shortened day. There was a shortened day. State repudiates the parties understanding defense rests, jurors sequestered overnight in a hotel, charge set for Tuesday morning. Now the same, no overflow room, no audio, no video access regime remained in effect. Public access, if any, remained limited to the courtroom seating and the pre-dawn line administration. Come outside at a certain time, your ass getting got. Further facts to be developed at the evidentiary hearings. On June 9th, charge, closing arguments, 3 hours of guilt deliberation. This was a quick ass case, bro. They gave him 35 years, bro, in a few days, bro. Thought the case was supposed to be a couple of weeks. 2 to 4 weeks, Craziness, man. Charge, closing arguments, 3 hours of guilt deliberation, guilty verdict, and the entire punishment phase, at which the state called no witnesses through a 35-year sentence all in the same day. The defense called one. they called his mom so that she came up and spoke and said, and testified that Carmelo's her oldest son and that he was very remorseful for the things that he did, trying to get the people, the jury or whoever to kind of, have some leniency on Karmelo Anthony. But to no avail, they still gave him 35 years in less than damn near 3 hours. Same on that day on June 9th. Anyway, no overflow room, no audio, no video access. The regime that they're running, this protocol, the regime, still remained in effect for charge, closing arguments, guilt deliberations, verdict, punishment, and sentence. No contemporaneous alternative access was provided for those not seated inside. G, the excluded public. The exclusions that followed were repeated and concrete. Jacqueline Vaughn traveled from North Carolina and on the first day of testimony found a line roughly 80 to 100 people, from which only about 27 were admitted. Tira Allen flew in from Arizona, observed jury selection from the auxiliary viewing room, and was told on June 4th that the room had been eliminated and was excluded from the courtroom on June 4th and June 5th. Bridget Smith attended on June 1, June 4, and June 5, and June 6, and confirms both the roughly 27-seat public cap and the elimination of the outside viewing locations once the testimony began. Kiara West was turned away on June 1st on a purported jury members only rule and was physically removed from the courthouse on June 6th. Physically? Jesus. But they're putting hands in people? Feet? Nasty. Because of the expressive content of her clothing. She probably had on something that was expressive, saying, they're not saying logo, so maybe you had on some free Carmelo. I don't know, but you didn't get that memo? That's crazy. Thelma Anderson was excluded on June 4th and 5th and on June 6th and was seated only in the mid-afternoon after substantial portions of that day's proceedings had passed. Throughout, no declarant observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions. H, the unrecorded agreement. The defense tried its case under that limitation in reliance on an understanding reached off the record. That shit crazy, bro. Yo, they was driving a hard bargain, homie. Yo, it was nasty work in the building, bro. Drop this shit in the middle of this shit. Watch that shit go up, bro. Yo, bro. Nah, son. This is crazy, bro. Shout out to everybody that was there, man. Shout out to all of you that was there. Because this was a lot, man. The same off-the-record method that hid the pretrial proceedings from the public also produced. Lead prosecutor proposed that the parties try the case clean, based on only what happened under the tent that day, with neither side offering character, reputation, or extraneous extraneous conduct evidence concerning either the Metcalf twins or the defendants. Let's read that line again, bro. They said they want them to try this case clean, based on only what happened under the tent that day, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. The terms were negotiated in meetings and calls on May 5th, May 8th, and May 11th, and on May 21st, 2026. The parties presented the understanding to the court itself in chambers off the record to avoid the media reporting on bad act evidence, and understanding was memorialized only as a deliberately generic motion in the mind and hand delivered to the court on the first day of trial, and it does not appear on the public docket. From that point forward, the defense tried its case under that limitation at every stage in reliance on the bargain. In voir dire on June 3rd, the defense did not explore with the panel the themes of let me see, they're on the panel. Okay, on the panel, the themes of a decedent's character and aggression it otherwise would have developed. In its opening on June 4th, it introduced none of them. Through the state's case on June 4th, 5th, and 6th, the defense let the state student witnesses leave the stand without confronting them with their own record statements to the police that Austin Metcalf was kind of like the aggressive guy. Let's read that line again. It's crazy. We're talking about why they didn't call no character witnesses and all that stuff. They agreed to this. Bro, they agreed to this in meetings on May 1st, 5th, 8th, and 21st and all that. To call no character witnesses, bro. No reputation evidence, no character evidence. They both parties agreed to this. What type of case is this, bro? Choo choo. Sound like the railroad was running that day. Sorry, bro. This is crazy, bro. OJ had a whole trial where he was in a Bronco like this with AC. They ain't had none of this for OJ. Yo, bro. Ted Bundy, whoever, bro, that you can name right now, bro. They didn't go through none of this shit, bro. And them people was serial, bro. Serial, bro. He was going to cross state lines doing everything they was doing. John Wayne Gacy. Want me to keep naming men? Son of Sam, bro. None of these people dealt with this, bro. It's crazy. All right, where we at? Through the state's case on June 4th, 5th, and the 6th, the defense let the state student witnesses leave the stand without confronting them with their own record statements to the police. So that's why people are saying, yo, the statements from the beginning with the witnesses, they didn't match up with testimony, but they didn't press them. You see what's going on. They didn't press them on these things to say, yo, bro, that Austin Metcalf was kind of like the aggressive guy on the team, that he got triggered, that Austin and Hunter, they're not going to let you disrespect them, that if Austin is about to get into a fight, you can tell, and that he could be a bit aggressive at times, and in abundance of caution, even narrowed the questioning, the understanding permitted. The defense designated no experts, foregoing a neuropsychologist prepared to explain how the defendant's epilepsy affected his perception of the threat, and a forensic psychologist prepared to address the adolescent brain development and the fight or flight response, because the state took the position that such testimony would breach the understanding. That's crazy, bro. Yo, they did him dirty, bro. Nah, bro. They did him dirty, bro. This is nasty work, bro. This is nasty work. Jesus Christ. The forbearance had a purpose. The payoff was to come in the defense case under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. So what you mean? Of course they want to know what happened under the tent. This only benefits the prosecution. The prosecution want to move from the cause of the event that happened, moving forward. Everything that transpired after that. He ran, he did this, and everything after that. The defense want to start from the actual event, which is the situation, the confrontation, to everything before that. Because everything before that could show a history. It shows patterns. It could show a history between them. It could get really in detail to the history of why he really possessed that weapon. They could go more into the history of who the twins are. Are they aggressive? Who are they? The prosecution didn't want to play that game because they knew that Karmelo Anthony really didn't have no background and no record like that. And he wasn't the one that was being like that and aggressive. The twins really had that kind of a reputation to be that. Even you see from the email that the cheerleader left, right? Look, this from the cheerleaders. Okay, look, he called my friend a fat. Look, Hunter stood up and called my homegirl a fat biatch. Look, he said that these hands is bisexual and that both girls and guys could get them. That's what Hunter said, right? So it ain't just Hunter, because look what she says at the end of this email. This is a cheerleader that cheers for his school. She's scared her death of them brothers. Scared to death. People knew about their reputation. Look what she says on the bottom. She says, listen, I would just appreciate it for my name to stay confidential, as I fear what they would do if they found out that I'm writing this to you. They, not him or Hunter by himself. They. You already heard the mother. She didn't care. You heard what she said. She basically was caping and capping for Hunter. Oh, that's how Hunter be. He's known to be like that, especially if he feel disrespected and this and that. But she ain't never tell him, yo, listen, why are you doing this to these little girls, man? You're going to grow up to be abusive and can kick down a woman, probably unalive a damn woman. You need to stop that before you disrespect me. But who knows? I done heard some allegedly that he was disrespected. They was disrespecting their own mama. They was disrespecting their own father. You see what I'm saying? So this is nasty work, bro. This is nasty, bro. Nasty. All right, cool. Let me see where we was at. Under the tent. It's nasty. The defendant would testify to the altercation like any other tent witness. Best that he didn't testify, bro. This is crazy, bro. I was confused. Should he testify? At first, I was like, yo, man, the prosecution's going to chew him up, bro. I'm telling you, them people good, son. And I was hearing about how good the prosecution was. I was like, I don't think he should do that. Then after you got the 35, I'm like, damn, man, he should have testified then, bro. It's crazy because, remember, we don't know what happened. Why did he have a knife? The defense only brought up in the very beginning he liked to go camping. That's it, bro. No more mention of why he had the knife. You're not going to bring that home. Only thing they're trying to do to humanize him is refer to him as Mello. Shit sounded like a gang nickname. What are you talking about, bro? Anyway, that's just my own take. Calvin is a lawyer, a defense attorney. He was saying that maybe it could help him with the name, shorten it to Mello. You could kind of see him like a young kid. Sound like King Von to me, bruh. But the nicknames, bruh, sound like Unfufu. Sound like Pookie and Ray Ray. I don't know. You do the math on that for yourself. The defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. I think they should have done. If they're going to present the self-defense case through him, they should have done this. He should have testified. They was getting real rid of it. He should have testified, bro. Because every other case that when I was doing a case-by-case comparison of cases in Collin County, I went through like 10 cases, bro, at least. Unaliving, poking cases, ones with weapons, straps. You know what I mean? One woman clapped her husband. Morgan Sims and D. Ray Sims was a man. He was found on the bathroom floor, smoked. She blamed it on her kids. She said the kids must have pulled the trigger. Guess how old the kids was? 2 and 6 years old. Pull what trigger? 5 pounds of pressure, you know. Pull what trigger? The woman skeeted out the crib. Skeeted out the crib. Left the kids in the house with the body, traumatizing her own children. Left the 2 kids, 2 and 6 years old, in the house with the body, bro. Police came to the scene, and whoever else came, paramedics, whoever the else came, found the body on the bathroom floor and the 2 kids in the house with the body. At trial, the prosecution was seeking like 25 years or something like that. She got up and testified for herself, though, talking about abuse that she was suffering with him. And she was the one taking the shower, even though they were saying that he was the one taking the shower. And then she came in there and clapped him. Bam. She says, I was in there taking a shower. He came in there and must have punched her, hit her, something like that. She fled, got the straps, came back and clapped him in the bathroom. That's what she said. She did. You know how much time she got? 55 years. That's a lie. I'm lying to you. 10 years. That's a lie. I'm lying to you. She was white and he was black. 5 years. That's a lie. I'm lying to you. 1 year. That's a lie. I'm also lying to you. She did it. She said she did it. She got 10 years probation. She didn't even spend a day. 10 years probation. Do you hear what I'm saying to you? Okay, cool. but she testified for herself. So I'm like, damn, maybe if I don't think he was getting off this case at all. He would have never got no 10 years probation. I don't think that it ever gave him that. But that's what maybe if you testify for yourself, maybe that could have helped you, bro. You know what I'm saying? Hold on, let me check on something real quick. Because if I'm reading this and y'all ain't dropping no likes, I might as well just end this shit right now. I'll read this shit tomorrow. So I don't know what the hell y'all think this is. I look like On Fufu or Booba the Fool. Okay. Don't play with me, man. I ain't the one that's begging. You see a lot of beggars on this. It ain't me. Okay, cool. Know it. Tell you right now. You just check on this right now. Okay, cool. Slap the like buttons, man. Slap the like buttons. Hold on, let me come over here real quick. Let me see if y'all hitting the poll. Let me just see what's going on. Let me check this. Let me just really check this for a second. Because y'all be bugging. The support that y'all give, shit. Like y'all be talking about Umar Johnson and everybody else online. Oh, y'all people is using. Y'all ain't helping nobody. Okay, I got 13 votes. Should have been more than that, but I accept that. At least some of y'all hitting that button. Okay, cool. Cool. Y'all slap the like button too. This is bad work, bro. Every pre-trial discussion, okay, let me just read the line before. The defendant would testify to the altercation with like any other witness free of character impeachment, and the defense would present its self-defense case through him. So why didn't they call him? Every pre-trial discussion presupposed it, and the prosecution repeatedly raised the ambiguous aggressor doctrine, the doctrine that matters only in a self-defense case built on such evidence as a trial counsel has sworn. In this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. I think that needed to be seen. On Monday, June the 8th, the final day of evidence, after the defense had spent voir dire its opening, the entire cross-examination of the state's case, and the first day of its own case honoring the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant. Let's listen to this, man. And asserted that the defense counsel had already opened the door by mentioning in opening that the defendant played chess, a position the court itself rejected. They did say he played chess, but what are they saying? The court then advised the parties that it knew of no mechanism at its disposal to enforce the understanding, and understanding that throughout the months the defense relied upon it, existed on no record because it had been reached and presented to the court off the record. And that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. Ugh. Allotted 10 minutes, the defendant elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses. And at punishment, the defense case was reduced to 3 pre-approved questions of the defendant's mother. I told you they called the mom. Three questions that they can only ask. This shit is crazy, bro. Can you see with the mother? The state, for its part, called no punishment witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately, exactly, and the lead prosecutor had described on May 11th that the agreement would operate. Punishment presentation will be confirmed by the reporter's record, and the state thus performed the bargain at punishment the day after denying that the same bargain covered the defendant's testimony. In the end, neither side put on character evidence. The understanding covered, the bargain was performed on both sides through the last day of the trial. The only term repudiated was the one most vital to the defense. the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, and under the understanding as the state itself, under the understanding that the state itself had repeatedly described it, he would testify like any other tent witness. And his elimination as a witness was devastating to a defense that turned on its own perception of the threat he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire, open and cross-examination, expert designations, or decision framework that had followed from the understanding. The expedited schedule, the Saturday court, and the 10 minutes to decide. They even had Saturday court dates. They was trying to get him up out of here fast, bruh. Fast, bruh. You ever went to your aunt's house? She got like 18 kids. Try to get your ass back. You supposed to spend the night? She gonna wait for Saturday or Sunday to hit. About to put you on a bus. You like, damn, you ain't gonna drop me off, Grant? I'm auntie? No, she couldn't wait. It's crazy. She tried to do a little favor for her sister or brother, your uncle. Crazy. Anyway, the trial itself was run at speed. At May 29th, the court announced its intention that the defense begin calling witnesses immediately upon the state's resting, so that no trial day would go unfilled, including Saturday, June 6, 2026, a day on which several defense witnesses were unavailable. Trial counsel told the court that the schedule could force the defense to call the defendant out of order. The state rested midday Saturday, and the defense began its case that afternoon. The repudiation of the parties, understanding described above and set out fully in part 4 below, erupted on Monday, June the 8th, the final day of evidence. When the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privilege and testify, the court allotted the defense 10 minutes to counsel a 19-year-old through it and denied counsel's request for additional time. They gave him how much time, bro? 10 minutes, bro. It's a kid, son. You got the weight of the world on you right now, bro. You about to waive your Fifth Amendment rights, thinking that if you're going to testify or not, or you're not going to testify right now, bro. Do you hear me? That's crazy, bro. It's insane to me. 10 minutes, that's it, bro. To decide whether you're going to testify in the realest thing in your life, bro. A M case. They running it like they selling hotcakes. They got you on the conveyor belt, bro. Jesus Christ. It's craziness, man. Where I'm at, 10 minutes. Whew. When the moment came for the defendant to make the most consequential decision of the trial, whether to waive his Fifth Amendment privileges and testify, the court allotted the defense 10 minutes to counsel a 19-year-old through it and denied counsel's request for additional time. The defense rested that day after a shortened session, and the jurors were sequestered overnight in a hotel, informed that if they did not reach a verdict on Tuesday, they would remain sequestered on Tuesday, June 9th, 2026. Look at that. They put that out there too to say, yo, look, man, if y'all don't find that, then y'all gonna have to stay limited to here, because you know you ain't supposed to be moving around in that like that. You're gonna have to stay here. So people are like, you know what? That's why they probably hurried up like that. Like, they trying to keep us here to Tuesday, bro. Nah, let's get this done right now. See what I'm saying, bro? They pressed them to do this faster, bro. I'm wondering how they did it all so quick. Why they deliberated for under 2 hours. They like, yo, they got that thing done. You heard the ding. Your sister ever had an easy bake oven when you was kids? And you used to eat all her brownies and the cakes? Bing! Yeah, that's how they dealt with this shit, like an easy bake oven, homie. Nasty work. Anyway. The court delivered its charge. The parties presented closing arguments, and the jury deliberated approximately 3 hours before finding the defendant guilty of M. in the punishment phase, evidence, argument, deliberation, and the rejection of sudden passion. They rejected that. Nasty. Was then completed, and the 35-year sentence was imposed before the day ended. The sequestration and deliberation chronology, widely and publicly reported, will be established at the hearing and confirmed by the court reporter's record. After the verdict, the sealed file, the missing record, and the televised defense of the closure. The secrecy outlasted the verdict. Trial counsel withdrew on June 10, 2026, and appointed appellate counsel was then replaced and present counsel. Hold on, wait. Let me go back. The secrecy outlasted the verdict. The trial counsel withdrew on June 10, 2026. The appointed appellate counsel was then replaced, and present counsel were substituted in on June 23, 2026. All while the 30-day deadline for this motion ran, the reporter's record remained wholly. Wholly what? Untranscribed. And the pleadings and the case file sat in the court's chambers rather than in a district clerk's public record sealed by an oral order. At a conference on June 29, 2026, the court advised that the entire court file had been sealed by an oral order, conditioned counsel's inspection of it, and inspection of it, and on agreement not to disclose what he observed. A conditioned counsel could not give, leaving the file available only in the chambers. 2 days after imposing the sentence, the trial judge gave a televised interview defending the restrictions, describing the decision to bar cameras and streaming as an easy decision, acknowledging that he sometimes thinks, playing with somebody's life here, thinks. You gotta think, bro. You gotta know. Judge Roach thinks maybe he should have at least audio streamed or something so people could hear it. Yes, what do you think, bro? Do something. This is why we all running around with misinformation and people are arguing about parts of the case. We arguing whether Karmelo came first or Austin came first. Like, what the hell? Everybody should know that. That should be just regular facts, bro. That's not no big thing to know, bro. We're arguing that. This is how much of a circus it became in an it show. I don't have to say the shh, right? Boy. Explaining that he declined to do so about the audio. So because he declined to do so because people are going to distort whatever happens. And people doing that now. So what's the point? In a written statement to Fox News, the judge added, "Now that the trial is over, it is important for me to provide transparency." And in a public letter of June 17, 2026, he thanked the other judges of the county for adjusting their own dockets to accommodate this trial, at the minimum raising a fact issue about available courthouse space, available staffing, and available alternatives that should have been considered before the overflow accommodation was withdrawn. Because the reporter's record of the trial has not been prepared, the official court reporter has advised counsel that no portion of the trial has been transcribed. Jan Duggar, court reporter. And because the case file has been held in the chambers rather than in a district clerk's public record, the recitation above is drawn from the indictment and the court's charge, the public docket, the court's own orders, and the public statements, the attached affidavits and declarations, and counsel's knowledge. Defendants will offer evidence at the hearing in support of grounds timely raised herein. Procedural background, timeliness, and jurisdiction. On June 9, 2026, a jury found the defendant guilty of M. And on that same date, the court imposed a sentence in open court. assessing the punishment at 35 years confinement in the Texas Department of Criminal Justice Institutional Division. On June 4th, 2026, the trial court signed the certification of the defendant's right of appeal, although the certification issued before the verdict, the judgment of conviction was rendered and sentence imposed on June 9th, 2026. And the notice of appeal followed. On June 10th, 2026. The defendant filed his notice of appeal, and the appeal was docketed in the Fifth Court of Appeals as cause number 0526000840-CR. On or about June 11, 2026, after the verdict, the sentence, the certification of the right of appeal, and the filing of a notice of appeal, the presiding judge gave a televised interview concerning this case, which aired on WFAA TV Channel 8. This motion is timely under Texas Rule of the Appellate Procedure 21.4a, being filed within 30 days after June 9, 2026. The date sentence was imposed in open court. The court retains authority to consider and rule on this motion through the 75th day after that date. And a notice of appeal, if any, does not divest the court of that authority until the appellate record is filed in the Court of Appeals, State v. Moore. Go into that, and then go into whatever the numbers of it. Because the sentence was imposed in open court on June 9, 2026, the 30th day to file this motion is July 9th, 2026, and the 75th day falls on Sunday, August 23rd, 2026. Subject to Texas Rule of the Appellate Procedure 4.1, the defendant requests a hearing and ruling no later than Friday, August 21st, 2026, to avoid any dispute over Rule 21.8's deadline. The defendant is presenting this motion within 10 days of filing, as Rule 21.6 requires, and contemporaneously requests that the court signed the attached order on presentment and set the motion for an evidentiary hearing so that the parties may present evidence and that the court may rule within the time rule 21.8 permits. Contemporaneously with this motion, the defense is filing motion to recuse the presiding judge because Rule 18A of the Texas Rules of Civil Procedure governs recusal in criminal cases. Remember, for them to have a new trial, even though they're saying that Judge Roach is supposed to be retiring or whatever the case may be, for them to go, but when they file for a new trial, he was the presiding judge. So he's the person that's going to have to make the ruling on that. So if he did this case and he said, I ran a really good trial, I ran a good case, right? Why would he want to give you a new trial if he's the one that ran the trial and he's the one that votes on if you get a new trial? Think about this. I want you to think and use your thinking caps. Okay? That's why they want to get him out of here besides any other reasons. But that's one of the reasons, because when you file this, he's the person that has that thing. So they want to bring in a whole new judge so that judge can make the decision on this. You see me? That's what another reason specifically why they want him recused. Get up out of here, sir. Okay, well, just broke it down. If you want to, look it up. That's a fact. All right. Texas Rule Governor. Recusal in many criminal cases. See Arnold v. State. I might even go through that case one of these days. We go through Arnold versus the state. Okay. All right. The defendant requests that the evidentiary hearing on this motion be conducted by the judge presiding after the recusal motion has been referred and resolved in accordance with that rule. This motion is supported by affidavit because it raises matters outside the trial record established by the attached affidavits and authenticating declarations, and it is timely filed and presented. The defendant is entitled to an evidentiary hearing, and the court would abuse its discretion in denying one. Reyes versus the state. That's the case that they sent. The court would abuse its discretion in denying one. Reyes versus the state is the case that this happened in. Rozelle versus the state is another case where this happened in. Hobbs versus the state is another case. Hobbs. I wonder if that's like the Hobbs Act. I don't know. I gotta go into that. Under these circumstances, refusal to hold a hearing would be an abuse of discretion because the motion and its supporting affidavits raise matters not determinable from the existing record that, if true, could entitle the defendant to relief. That is especially so here where the court reporter's record has not been prepared. The official court reporter has advised counsel that no portion of the trial has yet been transcribed, so the relevant proceedings cannot presently be reconstructed from any existing record. You didn't even have the transcripts. I spoke to the court reporter. The court reporter hit me back, Crazy, bro. First ground for new trial. The trial court violated the defendant's Sixth Amendment right to a public trial by materially restricting public access to trial proceedings without the findings and alternatives required by Waller, Presley, and by Stricker. Let me check on this real quick. Let me see what the hell going on. Okay, we in the chat. We writing. All right, cool. Oh, my man, Brace. Shout out Brace, man. I get like my guy Bracey, man. Do the right thing over there, man. Shout out to Ron Bracey, man. Gotta make sure I go follow the bro. You know what I'm saying? Straight. They looking like they got Bracey on trial. Yo, Brace, what happened? Brace. The hell? Let me bring out the records. Salute Sharon Bracey, man. That's my boy. Yeah. The issue is not whether the court had authority to manage courtroom security and capacity. It did. The issue is whether, after adopting an access order that foreseeably excluded members of the public from a high-profile criminal trial, the court made the findings, Waller v. Georgia, that it requires and considers the reasonable alternatives. Demands for contemporaneous public access, it did not. The court's order gave the general public only 10 minutes daily initial admission window, left roughly 24 seats for public observers in a nationally watched M trial, barred meaningful re-entry during proceedings, and provided no overflow room, no audio feed, no video feed for those foreseeably turned away. Once closure is shown, it cannot stand unless the record contains a Waller complaint justification for those restrictions. The existing record contains none, nor does the danger end with this. In a televised interview about a case that has drawn national attention, the court publicly defended these restrictions as the right way to conduct a high-profile trial, describing the decision to bar cameras and streaming as an easy decision and stating it had struck that balance pretty well. Should a trial be held? Should a trial held behind a 10-minute entry window with no overflow room, no audio feed, no video feed, no live stream be treated as an adequate substitute for an open courtroom? The public trial guarantee of the First and Sixth Amendments would be hollowed out in practice. What page me on? Shit, nigga. On 13, bro. You know what I'm saying? It's like 197 pages, bro. Thought I was on 20. Jesus Christ. Hold my hand with Jesus. Jesus. The restrictions here amounted to a closure of a courtroom imposed without the findings the law requires. The defendant does not contend with live streaming. It's constitutionally required in every case. The issue is that once physical seating was foreseeably inadequate, the court was required to consider reasonable alternatives to make Waller findings before excluding the public. An open courtroom belongs to the people of Texas who fund and sustain it. That is bars right there, bro. paying our taxes and all that. You kicking us out of something. What's wrong with you, bruh? Wrong with you, bruh? I think this the boom boom room? Are you kicking me out, bruh? An open court belongs to the people of Texas and the people who fund and sustain it. The openness of a criminal trial is among the oldest and the most settled features of Anglo-American justice. The United States Supreme Court has held that public and that press possess a right secured by the First Amendment and 14th Amendments to attend criminal trials, and that absent of overriding interests articulated in findings, a criminal trial must be open to the public. A presumption of openness inheres in the very nature of the criminal trial under our system of justice. For a public trial gives assurance that proceedings are conducted fairly, discourages perjury and misconduct, and guards against decisions based on secret bias or partiality. As the court observed, it would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which the criminal trials are conducted. Texas has long spoken to the same effect in its own voice. The Code of Criminal Procedure commands that the proceedings and trials in all courts shall be public. The Court of Criminal Appeals has embraced the presumption of openness recognized in Richmond newspapers, explaining that more than a century ago that the Texas Constitution is but in accord with the genius and spirit of our free institutions, which is intended to guarantee publicity to the proceedings of our courts. It's going to switch. Am I on 13? Check. I'm on 13 now. Right? These guarantees are not abstractions, and they are not held by the accused alone. The open trial guarantee belongs as well to the citizens of Texas in whose name the prosecution is brought and by whose taxes the courthouse and the court are sustained, and whose confidence in the administration of justice depends on their ability to see the justice is done. Public attendance is the mechanism by which the community observes that the courts it funds are functioning lawfully. A check on official power that the Supreme Court has repeatedly identified as the core purpose of the open trial guarantee. See Waller versus Georgia. When the public excluded from a Texas courtroom without lawful justification, that injury falls on the defendant whose Sixth Amendment right is violated, and on the community whose courtroom it is. And it is the defendant's injury that this motion vindicates the community's stake, underscores why the violation is neither technical nor trivial. A public trial is staged for two audiences at once. The first sits in the gallery, the citizen in whose name the case is brought, who watched to satisfy themselves that the state proves what it claims and that the accused is not quietly condemned. The second sits on a bench and in the jury box, the judge and the jurors, for whom the awareness of being watched is itself discipline, keeping them keenly alive to a sense of their responsibility and to the importance of their functions. Waller v. Georgia. A 10-minute entry window empties both galleries at once. It turns the public away before it can watch, and it relieves the court of the very audience whose presence is the discipline. What the order describes as access operated in practice as material exclusion. I like how they broke that down. You know what I'm saying? Like, the people in the courtroom is there to watch them, the public, to make sure that they doing what they need to do, the judge and the jury. We there watching too as a public. And we pay our tax-paying dollars. So at the end of the day, this is our courtroom. Just like we say the police work for us because they paid by the taxes. Same thing. It's crazy. History explains why the law guards the open courtroom so jealously. The public trial guarantee is a longstanding safeguard against secret proceedings. It has always been recognized as a safeguard against any attempt to employ our courts as instruments of persecution. What openness protects, secrecy endangers. What openness protects, secrecy endangers. That's bar. A proceeding the public cannot watch is one in which the ordinary checks on error, overreach, and bias quietly fall away. That is the structural risk a closed courtroom creates. Whether or not anyone can later prove the harm the secrecy concealed, which is precisely why the law treats the deprivation as structural and does not put the defendant to proof of a hidden jury. A courtroom may be closed only rarely and only on the showing while it requires. The most directly applicable appellate authority on this precise question is a published decision of the Court of Appeals, handed down months before the trial began. The Fifth Court of Appeals held that a trial court violated the defendant's Sixth Amendment right to a public trial and ordered a new trial, where the court, citing the courtroom, damn, what case is that? Strickler versus the state. Strickler versus the state. I got to go through some of these cases. I'm most definitely going to read some of these cases as well. Yeah, I'm back in my Matlock bag, bro. It's over. I got to read through some of these cases myself, bro, because they actually handed down, okay, cool. So where the court, citing courtroom space and a generalized security concern, refused to seat a single member of the public during a jury selection without first considering the reasonable alternatives the law requires. Because Strickler was designated for publication under Texas Rule of the Appellate Procedure 47.2b, it is published memorandum opinion of this Court of Appeals and thus the most directly applicable appellate authority on the public trial questions, and having been issued months before this trial, it was available for the trial's court review when the court entered the amended order and closed these proceedings. The closure here was therefore not the resolution of an unsettled question. It ran headlong into the recent published decision of the very court that reviews this one. Every justification the Fifth Court rejected in Strickler is a justification that the court invoked here. And that rejection was on far more extreme facts there. And the court refused to seat one observer because of veneer-filled gallery. And here the court rationed the general public to roughly 24 rotating seats across every stage of nationally watched murder trial. I don't like to say the word. There, the trial court declined to split voir dire to make room, explaining that I am not going to spend 2 days picking a jury. The Fifth Court held that space and overcrowding, though legitimate concerns, must not outweigh the defendant's Sixth Amendment rights because there are readily available alternatives, and that neither convenience nor judicial economy can constitute an overriding interest. Here, the record and the court's own public statements at least raise a fact issue that reasonably alternatives existed, including larger or additional courtroom space, a live audio or video feed, and an overflow room accommodation the court used during jury selection and then withdrew. And where the Strickler court faulted, right? And where the Strickler court faulted the judge for failing to identify a specific concrete fact of danger, the order here rests on the same generic recital that this is where the recital at, right? Okay, recital that unrestricted access may compromise security, entered without a hearing if excluding a single mother of the public from the jury selection required a new trial in Strickler. Damn, he might have some good cases for this. One single mom, bro, got him a new trial, bro. Just one person. Then the reoccurring exclusion of numerous members of the public from testimony and testimony and punishment after the court withdrew an available overflow alternative and made no Waller findings cannot be dismissed as trivial. A second court of appeals reached the same result weeks later on the facts that materially indistinguishable from the space rationale invoked here in Hernandez versus the state. The 14th Court of Appeals reversed a capital M conviction and ordered a new trial because the trial court closed voir dire to the defendant's family and the public, citing an 80-person veneer and a lack of physical space without conducting a Waller analysis, making findings, or considering reasonable alternatives. The court held the concerns about space must not outweigh the defendant's Sixth Amendment rights and admonished that trial courts are expected to know and apply this basic rule. Strichter and Hernandez are thus recent published Texas decisions holding that a space-based closure of a jury selection entered without Waller findings or the consideration of reasonable alternatives is structural error requiring a new trial. And both were available for this court's review before this trial. Strichter and Hernandez addressed the merits of a space-based closure. Dixon and the preservation authorities address when the complaint must be raised. The defendant satisfies both rules here because the closure was administered off the record and as applied, exclusion became apparent only after the trial. The Court of Criminal Appeals has likewise reversed a narrower version of this problem in Stedman versus the state. The court reversed a conviction and ordered a new trial because the trial judge excluded the defendant's family from voir dire out of a generalized concern about space without articulating a specific threat. And he done got family that got kicked out of there. That's a fact. I read that earlier. Articulating a specific threat and without considering reasonable alternatives. This case is Stedman magnified at every dimension. The court excluded not one family, but the general public, not from voir dire alone, but from every stage of the trial on findings no less than generic. That unrestricted access may compromise security, juror privacy, and a fair trial without a hearing, and after using, then abandoning the very kind of overflow alternative Stedman faults courts for failing to consider. So if barring a single family member from jury selection was structural error demanding a new trial, excluding members of the public from substantial portions of the jury selection testimony and punishment is so, the Sixth Amendment to the United States Constitution guarantees that the accused in a criminal prosecution the right to a public trial and guarantee applicable to the states through the 14th Amendment. The Texas Constitution independently secures the same right, providing that the accused shall have a speedy public trial. The proceedings and trial in all courts shall be public. The right to a public trial is not confined to the presentation of evidence. It extends to a jury selection. Before a trial court may exclude the public from any part of a criminal proceedings, it must satisfy the four-part test of Waller v. Georgia. Part 1, the party seeking to limit access must advance an overriding interest that is likely to be prejudiced. 2, any limitation must be no broader than necessary to protect that interest. 3, the trial court must consider reasonable alternatives to closing the proceedings. And 4, a trial court must make findings adequate to support the limitation. The Court of Criminal Appeals has adopted and applied this test in Stedman versus the state. This trial, the trial court bears the burden of considering reasonable alternatives. The balance of interest must be struck with special care, and findings by the trial court are the linchpin of the Waller test, which is a 4-part test. We just went through that test, right? The right of a public access applies with particular force to the selection of the jury. The Supreme Court has held that guarantee of open criminal proceedings reaching the voir dire of prospective jurors. Because the selection of jurors has presumptively been a public process without, has presumptively been a public process with exceptions only for good cause shown. Open jury selection was the settled practice in America when the Constitution was adopted, and the court emphasized that the court's proceedings conducted in the secret frustrate the very public interest that open selection exists to serve. Closure of a jury selection is therefore permissible only on the same showing of an overriding interest. Oh, I'm down there. I'm on 19. All right, cool. Narrowing Taylor and specific findings that Waller and Press Enterprise require, the order's restriction nonetheless applied to jury selection along with every other phase of the trial conducted behind the same closed doors and unsupported by any such findings. C, 10 minutes a day did not keep this courtroom open to the public. A reviewing court first characterizes the restriction. A full closure is tested under all 4 Waller factors. A partial closure is tested under the same factors, with the first requiring a substantial rather than an overriding reason, and only a true trivial or de minimis restriction leaves the public trial right unimplicated. The court's amended order regulating the trial's proceedings, media access, security, and courtroom decorum, attached as Exhibit 1, was not a trivial restriction. It provided an pertinent part. The courtroom shall open each day of trial at 8:30 a.m. Entry shall be permitted beginning at 8:30 a.m. for members of the media, at 8:40 a.m. for designated family members, at 8:50 a.m. for members of the general public. No more than 9 members of the media, legacy media, shall be permitted in the courtroom at any one time. Seating shall be on a space available basis, and the courtroom's doors shall close promptly at 9 a.m. and individuals arriving after that time shall not be admitted until a recess. Once admitted into a courtroom, no person shall leave and re-enter during the proceedings except during a recess. By its terms, the order only affirmative window for the general public to enter was the 10 minutes between 8:50 and 9 a.m. The remainder of the provision spoke in terms of exclusion. Doors shall promptly close at 9 a.m. Individuals arriving afterwards shall not be admitted until recess, and no person shall leave and re-enter during the proceedings except during a recess. The order capped media presence at 9 persons, made seating space available, and contained no provisions for admitting members of the public as seats became open during the proceedings, nor did it furnish any overflow room, audio feed, or video feed for the public unable to be seated. By its terms, the amended order governed all aspects of the trial proceedings, and it remained in effect and was applied throughout. The restrictions operated continuously and were not confined to any discrete portion of this case. They governed the jury selection process, the guilt innocence phase, and the punishment phase alike. The closure was therefore pervasive rather than incidental, depriving the public of access to every stage of the proceedings at which the order applied. The cumulative and practical effort of these provisions was to exclude members of the public from the proceedings at every stage at which the order applied, including jury selection, the guilt innocent phase, the punishment phase, which constitutes a closure subject to Waller. The defendant bears the initial burden to show that the trial was closed to the public, but that burden is carried on the totality of the evidence. And the inquiry does not turn on whether the defendant can show that any particular person was actually excluded. The initial burden rests on the defendant and of reaffirming that the closure is determined by the totality of the evidence rather than whether a spectator was actually excluded. The focus is not ooh, yeah. The focus is not whether the defendant can show that someone was actually excluded. The reviewing court instead asks whether the court fulfilled its obligation to take every reasonable measure to accommodate the public attendance, which they didn't. The cumulative effect of the non-media cap, the 10-minute public entry window, and the space available seating, the no re-entry rule, and the absence of any overflow rooms or live streams establishes that the members of the public were excluded, and the defendant the defendant has carried his burden to show that the proceedings were closed. And these facts are further established by the accompanying declarations of members of the public who sought to attend the trial and were denied entry into the courtroom. Those declarations those declarations executed by members of the public who came from across the country to attend established the closure concretely and consistently, and no witness observed any disturbance or security incidents that would explain it. Jacqueline Yon traveled from North Carolina on the first day of testimony. She found a line roughly 80 to 100 people and watched as only about 27 were admitted with no overflow room provided for the remainder. Tira Allen flew from Arizona and observed the jury selection from an auxiliary viewing, the TV or something, location she knew as the Oval Room on June 1st and June 3rd, and on June 4th. She was told that the accommodation had been eliminated, the overflow room, and she was excluded from the court on both June 4th and June 5th. Bridget Smith attended court on June 1st, June 4th, June 5th, and June 6th, and confirms that the public seating was capped at roughly 27 seats, and that the admission was divided into two lines, one for the media list and one for everyone else, and that the outside viewing, yeah, bro, tired. But I'm reading this shit for y'all, right, bro? Tired as hell. And I'm reading this shit, bro. Straight. 1,000 pages, nigga. I'm reading through this shit like a boss. Eyes is blurry. I'm seeing no kind of blurred vision. It's great. Shit. Need some coffee or something to read this. I'm gonna make some coffee too. Something. Straight. This is crazy. The admission was divided into two lines, one for the media list and one for everyone else. And that the outside viewing location used during jury selection was eliminated once testimony began. Tamitra Carter arrived before dawn, and though identified as number 7 on the early arrival list, was removed from the June 5th line and lost the morning's proceedings because only about 27 public seats were available. Kiara West, a member of the general public with no media affiliation, was denied entry on June 1st on a purported jury members only rule and was physically removed from the courthouse on June 6th because of the expressive content of her clothing. And Tony Toussaint, the defendant's own grandmother, attested they're Haitian or something. They're Haitian. They're French. Probably Creole background. Yeah. And Tony Toussaint, you would probably think that's Toussaint, but it's Toussaint. The defendant's own grandmother attests that the family access was capped at 8 seats in total, so that the defendant's grandfather and aunts were excluded from his trial altogether. And that even those admitted were required to register a day in advance and were warned that visible facial expressions could result in an early removal. Let me at least read this part. One member of the public attended the trial nearly in its entirety and provides a day-by-day account that corroborates each of these features. from inside. Nakia Washington traveled from Cincinnati, Ohio, and was present at the courthouse June 1, June 3rd, June 4th, June 5th, 6th, 8th, and 9th, 2026. During the jury selection, the court used an auxiliary viewing courtroom, the memorial room. Okay, so the memorial room was used for that. And then they used another one, which was the oval room. So we could see how these courtrooms are listed. They got names for these courtrooms. Okay, cool. One was called the oval room. We read that. This one's called the memorial room. Okay, we're paying attention. That seated roughly 60 members of the public and carried a live video and audio feed from the proceedings. On June 4th, the first day of testimony, the public was informed only after arriving that the overflow room would not be available for the remainder of the trial, and access was therefore confined to approximately 27 seats inside the courtroom with no overflow room audio feed or video feed of any kind. Access each day was governed not by the order's admission time, but by pre-dawn line that formed as early as 4 a.m. to 4:30 a.m., was counted off in groups of 27 and was inconsistent and at times chaotic. And although Miss Washington ultimately gained entry on each day she attended, she was excluded from the morning proceedings on both June 4th and June 5th, and admitted only in the early afternoon after substantial portions of that day had already passed. Damn. This is crazy, bro. It's crazy. I'm gonna break this down in a couple of parts, bro. But I think I'm gonna read a more chunk of this right here again. But I think I'm gonna go get me some coffee. Hour and 30 something minutes is good for a read. I'm gonna start another live after this one, so make sure y'all all subscribe and hit the notification bells as well. I'm gonna start it from right here. I'm gonna continue these lives just like this. This is what I'm gonna do. This is an hour and 30 minutes. I think that's good for part of a read. I'll go make some coffee, and we could just do this shit all night, bro. All night long, transcripts all night. Choo choo on the railroad. Try to railroad my boy, bro. Try to railroad him, bro. Based on what the judge set, the parameters that the judge set, bro. Son, he only had 10 minutes. The defense only had 10 minutes to see if he would have waived his Fifth Amendment rights and would he testify in his own trial. They only had 10 minutes time to talk to him, bro. That's it. No extra time was given to talk to a 19-year-old about making the biggest decision of his life right now, which is testifying in an M trial. Do you hear me, bro? No cameras, no live streams, no nothing. If you came and stood by the grass at a certain time, you could be in contempt of court. No overflow room. I told you that Diddy trial. They had like 3 overflow rooms. If one was packed, they opened up a new one. You just go to another kid. Bro, and that was Diddy's trial, bro. You know how many people was outside? You know how many people? You saw it. I was there. You saw me. You know how many people was outside that thing, passerby, just people just walking through. Oh, what's going on there? You parlez-vous français? No, I don't speak French. Who's here? Diddy. Oh, Diddy is there. Oh, my goodness. What are you talking about? You seen everybody there, bro? They opened up new overflow rooms. I'm telling people, yo, go in the court, go see for yourself. They're like, I could go in there. You sure, son? I said, yo, go look for yourself, bro. How many people? Ask them how many people I told go in the court. How many people? I was like, yo, go and go see for yourself. And everybody went in like, oh my God, Uda, thank you, bro. I went in there, yo, I saw Diddy up here. He had the gray hair, son. It's crazy. And that's a federal case, bro. And that was a circus. Diddy's trial was a circus, bro. That needed some restrictions on that shit. That shit was a circus, bro. They could call no character evidence, no character witnesses. And if he was the only one that could really testify to his own self-defense, Karmelo, and if he was to testify, he had to testify like every other witness that was under the tent to all these events, and everything was limited to everything that happened under the tent, nothing before, nothing after. Who does that benefit but the prosecution? That don't benefit the defense. Defense need to go past what happened before the event to say this is what happened. This is why things happen. This is Karmelo's mindset. This is why he had the knife. This is why he was thinking like this. This is why he was in his fight or flight mode. This is what he was thinking. Past people was pushing up on him. Every time he left school, there was some racist people that came around there, and this is what he had. Somebody pulled a weapon on him one day. So this is why he had something just in case. Who knows the reasons for anything? I told you, from the event, everything happens from here. Boom, this is the event. From here, when the event happens, right? The prosecution want to go from where the event happens to forward. They want to go forward, whatever happens after the event. Yo, you unalived him, whatever happened after that. He ran, what he did. He did. Okay, what he said. Oh, he said this. Did he testify? Did he make any statements? They want to know all of that. They just want to move from there forward. The defense's rules and job is to go from there backwards, going into the character of the twins, going to even Karmelo's character to compare it to the twins, to say, look, who was more of that? Who was the bully here? Who was the aggressor here? Did you not know that these brothers had an aggressive nature? You didn't know that? Then the witnesses, they said that the witnesses that they brought on, right? After the witnesses got off the stand, they just left without no pushback, no nothing of their first statements that was made. I see Taz going off one day with Andrew Wilson. The statements that they made, what are you talking about? It ain't go the same as the testimony. I've been saying the same thing, but I'm saying, look, they couldn't even speak to the facts that if the twins were aggressive, they were known to get mad, get hype at practices and all of that. They had like a bully type of a vibe. They couldn't speak to none of those elements. Nothing, bro. This was limited. His hands was tied, yo. The best thing that Karmelo could have did is testify in his own case, bro. That was the best thing. I'm telling you, when this case started, I said, man, bro, I hope you don't go up on that stand, bro, because they're going to cook him, son. He's a kid, bro. Grown people get cooked on that stand, bro. You could be telling the truth, son. Your birthday. Who's your mother? Who's your father, bro? Them prosecutors, when they get the cooking on you, bro, they'll have you looking like a liar, like you don't know who your own mother is. You'd have think you was damn Orphan Annie. You'd have thought you was Orphan Annie, bro. They will make you seem like Orphan Annie. This is how good these people are, bro. You be up there telling straight truths, and they be like, have you looking, questioning your own self, have you looking crazy? I'm like, I don't know if you should testify, bro. But based on how everything turned out, he was the best person to speak to his defense because, one, he was under that same tent. And remember, everything was limited to the tent and everything forward. No evidentiary evidence, nothing, bruh. Nothing. This case benefited the state. This is an open and shut, choo-choo, road rail. Straight, bruh. This is just a fact, bro. You don't have to, I don't have to have a side in this. This is just a fact, bro. I don't care if you white, you black. I don't care if you on this side or that side. Metcalf could look at this and say, yeah, this was a road. This was a road, bro. It's a fact, bro. The boy about to make the biggest decision of his life, bro. Whether to waive his Fifth Amendment right. And he was only allotted 10 minutes for your counsel to talk to you and talk to you about should you go and testify for yourself. Remember, it's ultimately your own decision to testify. It's your decision, regardless of what nobody telling you in your head. It's your decision. They only got 10 minutes to talk to you, bro. Then you're like, yo, come on, we need a little more time. We're just trying to get, weigh out some of the factors and stuff like that. 10 minutes, bro. Remember, they trying to prep you real quick if you're going to do it. You probably need a little 30 minutes. That's not even enough time. You need an hour or something. That's not enough time. There's never enough time for this, bro. You can never prepare yourself to go speak in front of a judge in a court. You got a traffic ticket. You up there fumbling. I made the right. I wrote the right on red. Traffic court, bro. You over there fumbling in traffic court, bro. This is court, bro. You know court get the jitters in you, bro. Don't matter what it is when you got to start to speak for yourself. Some people are scared. Some people are not public speakers as well. So you need time to prep them real quick. Yo, look, if you is going to go, look, just be prepared for this, this, and that. Boom, that. Just in case he asks you that, take your time. Don't rush to answer no questions. You got enough time. You can take as much time as you want. Hold on. Just wait. You know what I'm saying? They could talk to you about what you need to do. They wouldn't even give him 1 minute extra. Oh, bro. I'm going to be back in a minute, bro. This is crazy, man. Shout out to y'all, man. Hopefully when I come back, y'all be doing some good things and supporting the stream like my bro Sharon Bracey. Because I'm over here working. I'm tired, yawning. I'm working. But y'all don't respect the grind. Y'all don't respect the hustle. Y'all giving y'all money to OnlyFans. You're a woman, you're giving your money to OnlyMans. Y'all over here super chatting to be down with somebody online. Niggas don't know how to read. The reading rainbow. Contemporaneously can read anything. Y'all ain't even saluting that. The nigga know how to read. You dumb or you dumb. I ain't never been hooked on phonics yet. And I came from them streets. I'm gonna bring 10 of my friends from the streets right now. Let them read to you right now. Let them read any of them words. My mom would say, my mom would say that the happiness is like sunshine to come down when you're feeling blue. They would sound like the water boy, bro. It's a fact, bro. I taught myself to read. Hope you know that. Think I'm joking? I taught myself to read, bro. No teacher taught me. I taught myself to read. Do you respect that? So I can't be here, man. You know what I mean? I'm gonna start a new live. Salute to all my people that supported. Drop the like and hit the poll. Y'all ain't even doing that. Sad work with y'all, bro. Sad work. If hitting a like or sharing or subscribing and all that shit could save a life, everybody be dead, bro. The whole world be dead. Whole YouTube be dead, bro. Trade, bro. Whole YouTube be dead, bro. That's nasty work, bro. It's really nasty work, bro. So salute to all of y'all, man. I love y'all all, man. I'll be back in a minute, man. I'm going to get some coffee, and we're going to try to read through these documents and get through the rest of it, man. So, but this was a road, man. Hopefully, y'all come back with another more spirit, and y'all liking, y'all hitting the poll from the very beginning at least. I'm not a person to ask you for money. I never did. I never do, right? But at least you can show love by smashing the like button, hitting the poll, subscribing, sharing, doing those kinds of things. Okay? I love y'all online. I appreciate y'all all. We're going to get through it. I'm going to help y'all to learn the rules around here. This is called on go. And we on go for each other. We're not on go individually and for ourselves. That's how come people get to taking advantage of us. Because we keep trying to be individuals. Not everybody's a fucking Genghis Khan. Everybody ain't strong enough. So who's not strong need to get with stronger people. Who's not leaders need to get with leaders. Who's not confident need to get with confident individuals. And this is how we come into a cluster. And that's how we all feed off all our attributes. And this is how we become something strong. You get what I'm telling you? This is called on go, and we on go together. Period, point blank. Ask anybody that know me from this thing, bro. Stop playing me. In front of that court, how many people I supported, how many people I was like, yo, what? You ain't doing that to them. You dumb, you dumb. I always make myself readily available. I'm helpful. I'm full of help. How many people on here, people try to play you on this line, bro? And wild them up. Don't play with me. Don't play with her. Don't play with him. You stupid. Stop that, bro. Don't do that to them, son. Don't do that to us. Don't do that to them, bro. You dumb, you dumb. Because that's how we doing it over here. We on go together. So make sure you're a part of the Go Gang, man. And you on go, man. Subscribe to the channel, hit that notification bell, and make sure that you're notified when we on go. You heard? That's a fact. It's on Jesus Sandals. Learn it.
All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, all my niggas turn shooters. All my ops turn racks. All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the